In the early 1960s, long before police officers routinely recited a familiar warning, American interrogation rooms were quiet, closed spaces where authorities spoke and suspects listened. In Phoenix, Arizona, in 1963, a young man named Ernesto Miranda sat across from two detectives in such a room. He was not violent, not educated in the law, and not aware that the Constitution contained words written specifically to protect him. The officers asked questions calmly, methodically, and without interruption from a lawyer. Miranda did not know that he could refuse to answer. He did not know that silence was his right. He only knew that the people questioning him represented the power of the state, and that speaking seemed expected. At that time in American history, confessions were treated as the most reliable form of evidence. Courts believed that if a person confessed, the truth had been revealed. Judges rarely questioned the emotional pressure created by police questioning, especially when there were no visible signs of violence. As long as a suspect was not physically abused, a confession was usually considered voluntary. This belief shaped thousands of criminal cases, and it created an environment where knowledge of the law became more powerful than the law itself. The police knew the rules, the suspect often did not. Miranda was questioned for approximately 2 hours. When the interrogation ended, he agreed to sign a written confession. At the top of the document was a short statement declaring that he had confessed voluntarily, with full understanding of his rights. In reality, no one had explained those rights to him. The sentence was a formality, a legal assumption rather than a proven fact. Miranda signed the paper because he believed cooperation was the only reasonable path forward. That single act, quiet and unremarkable at the time, would later become one of the most examined signatures in American legal history. When Miranda's case went to trial, his court-appointed lawyer argued that the confession should not be admitted into evidence. The argument was simple, but unpopular. Miranda had not been informed of his Fifth Amendment protection against self-incrimination, and therefore his confession could not truly be voluntary. The trial court disagreed. The confession was allowed. The jury convicted him, and he was sentenced to decades in prison. There was no sense of injustice in the public eye. The system appeared to be working exactly as it always had. Yet, beneath the surface, the constitutional question remained unsettled. The Fifth Amendment promised that no person would be compelled to testify against himself, but the meaning of compelled had never been clearly defined. Was physical force required, or could pressure, fear, and ignorance achieve the same result? For years, the courts had avoided answering this question directly, but by the 1960s, the United States Supreme Court was beginning to reconsider how power should be balanced between the government and the individual. Miranda's case slowly moved upward through the legal system until it reached the Supreme Court, where it was joined with several similar cases. Together, they forced the justices to confront a reality that had long been ignored. A right that is not understood is a right that cannot protect anyone. The court now faced a decision that would determine whether the Constitution merely existed on paper or whether it would speak clearly to every person who stood alone in a police interrogation room. This was the moment before a change that would echo through every police station, courtroom, and television crime drama in America. Ernesto Miranda did not know it, but the law was about to learn how powerful silence could be. When the case reached the United States Supreme Court, it arrived at a moment when the nation itself was quietly questioning authority. The 1960s were marked by civil rights movements, protests, and a growing belief that government power needed limits. Inside the Supreme Court building, however, there were no chants or raised voices. There were only 9 justices, stacks of legal briefs, and a single unresolved question. Could a confession truly be voluntary if a suspect did not understand that silence was an option? Chief Justice Earl Warren understood that this case was not really about crime rates or police efficiency. It was about imbalance. In an interrogation room, the state controls the space, the time, and the knowledge. The suspect often controls nothing. The justices examined transcripts of interrogations and read psychological studies describing how pressure, authority, and fear can influence human behavior. They did not accuse police officers of cruelty, but they acknowledged something more subtle and more dangerous. Even polite questioning can become coercive when one side holds all the power. The court focused closely on the Fifth Amendment. For decades, it had been treated as a protection against physical force, not against confusion or ignorance. But the justices began to see the amendment differently. They reasoned that a right cannot function if the person who holds it does not know it exists. Silence, they concluded, is meaningless unless it is understood as a legal choice rather than an act of defiance. Without that understanding, speaking becomes almost inevitable, and inevitability begins to look very much like compulsion. Opponents of Miranda's argument warned of chaos. They claimed criminals would escape justice, that police investigations would collapse, and that public safety would suffer. The court listened carefully, but it was not persuaded. The Constitution, they believed, was not designed for convenience. It was designed for protection, especially in moments when individuals are most vulnerable. The justices concluded that efficiency could never be justified by the erosion of a fundamental right. In June 1966, the Supreme Court announced its decision. By a narrow margin, the court ruled in favor of Miranda. The opinion stated that before custodial interrogation, law enforcement officers must clearly inform suspects that they have the right to remain silent, that anything they say can be used against them, that they have the right to an attorney, and that one will be provided if they cannot afford one. These were not new rights. The court emphasized that they had always existed. What was new was the requirement that the government must speak them out loud. The ruling did not free criminals en masse, nor did it dismantle policing. Instead, it reshaped procedure. Interrogation rooms became places where a short, formal warning marked the boundary between lawful questioning and constitutional violation. The words themselves were simple, but their meaning was profound. For the first time, silence was officially recognized as an active, protected choice rather than a suspicious act. Ironically, Ernesto Miranda himself did not benefit in the way many imagined. After his original conviction was overturned, he was retried without the confession and convicted again based on other evidence. He would later be released and eventually live a quiet, troubled life. But yet his name became immortal, spoken daily by police officers across the country, often without any awareness of the man behind it. Miranda v. Arizona did not make America less safe. It made the law more honest. It acknowledged that justice does not begin with a confession, but with understanding. In doing so, the Supreme Court transformed a moment of silence into one of the strongest voices for individual rights in American history. After the Supreme Court issued its ruling, the change did not arrive dramatically. There were no sirens, no public ceremonies, and no immediate sense that history had shifted. Instead, the decision moved slowly and quietly into daily routines. Police departments across the United States revised their training manuals, legal advisors rewrote standard procedures, and officers began memorizing a short script that would soon become one of the most recognizable legal statements in the world. The words were spoken calmly, often mechanically, yet they carried the weight of centuries of constitutional thought. At first, many officers resisted the change. Some believed the warning weakened their authority. Others felt it placed unnecessary barriers between law enforcement and truth. Yet, as time passed, something unexpected happened. Investigations continued. Confessions still occurred. Criminal cases did not collapse under the weight of constitutional language. Instead, the warning created clarity. Both the officer and the suspect now understood the rules of the conversation before it began. Silence was no longer suspicious by default. Speech was no longer assumed to be harmless. Outside police stations, Miranda v. Arizona began to shape American culture in subtle ways. Television crime dramas incorporated the warning into their scripts. often treating it as a dramatic moment of closure. Viewers who had never opened a law book learned their rights through fictional arrests. The Constitution, once distant and abstract, became something people could recite from memory. This public familiarity transformed legal awareness from a privilege of lawyers into shared cultural knowledge. At the same time, the decision influenced courts far beyond interrogation rooms. Judges increasingly questioned not just what the law allowed, but how power was exercised. Miranda became part of a broader legal shift that emphasized fairness, dignity, and informed consent. It reminded the justice system that procedures matter because people matter. The ruling did not suggest that suspects were innocent or guilty. It insisted only that they be treated as thinking individuals rather than passive subjects of authority. Critics continue to argue that Miranda favored criminals, but decades of legal analysis told a different story. Courts repeatedly affirmed that the warning strengthened prosecutions by ensuring that confessions were truly voluntary and therefore more reliable. When a suspect chose to speak after being informed of their rights, the confession carried greater legitimacy. The law had not silenced truth, it had clarified it. Over time, the phrase, "you have the right to remain silent," became so familiar that it risked losing its meaning. Yet beneath its routine delivery lay a powerful principle. The government must explain itself before it questions its citizens. This idea, simple on the surface, represented a profound shift in how authority was understood. Power was no longer absolute in closed rooms, it was bounded by spoken acknowledgement of individual rights. Miranda v. Arizona stands today not as a symbol of defiance, but of balance. It did not remove the power of the state, nor did it elevate suspects above the law. Instead, it drew a clear line between questioning and coercion, between silence and surrender. In doing so, it quietly reaffirmed the Constitution's promise that justice begins with understanding, and that even in moments of suspicion, a person does not lose their voice or their choice. As the years passed, Miranda v. Arizona settled into the structure of American law, not as a radical experiment, but as an accepted rule of fairness. New generations of police officers learned the warning as naturally as they learned how to use a radio or write a report. For many of them, it no longer felt like a limitation, but a boundary that brought order to uncertainty. The moment the warning was spoken, everyone in the room understood where authority ended and choice began. Yet, the case never stopped being debated. Courts were repeatedly asked to clarify what counted as custody, what qualified as interrogation, and whether a suspect had truly understood the warning. These questions revealed something important. Miranda was not a rigid formula, it was a living principle. It required judges to examine real human situations rather than rely on assumptions. The law became less mechanical and more attentive to context, language, and vulnerability. In some cases, the Supreme Court allowed limited exceptions, recognizing that emergencies sometimes demanded immediate action. In others, it reinforced Miranda's core logic, reminding the nation that convenience must never outweigh constitutional protection. Each decision added another quiet layer to the original ruling, shaping a legal landscape where rights were not absolute in theory alone, but negotiable in practice through careful reasoning. Beyond the courtroom, Miranda's influence reached deeper into American identity. It reinforced the idea that citizenship includes knowledge. A person does not need to be wealthy, educated, or powerful to possess rights, but they must be told those rights exist. This principle subtly challenged older hierarchies where authority spoke and obedience followed. The warning transformed the moment of arrest from one-sided control into a legally structured encounter. Ernesto Miranda himself remained a distant figure in this evolving story. His life after prison was unremarkable and at times tragic. He died years later, far from the Supreme Court that made his name famous. Yet his legacy endured in the everyday interactions between the state and its citizens. Millions of people who never heard him personally benefited from a protection he never fully enjoyed. Today, the Miranda warning is spoken without reflection, sometimes even without understanding, but its continued presence is a reminder that constitutional rights are not self-enforcing. They survive only when they are clearly stated, repeatedly honored, and publicly understood. Miranda v. Arizona did not solve every problem in the justice system, but it changed the tone of power. It replaced assumption with explanation, force with formality, and silence with choice. In the end, the case teaches a simple, enduring lesson. Justice does not require shouting. Sometimes the most profound change begins with a calm sentence spoken before a question is ever asked. By the middle of the 20th century, police interrogation had become a carefully practiced craft in the United States. Officers were trained not simply to ask questions, but to control atmosphere. The rooms were small, often windowless, designed to isolate suspects from time and distraction. Chairs were placed deliberately. Lighting was chosen to be functional rather than comforting. None of this was accidental. It reflected a belief that truth emerged most clearly when pressure quietly narrowed a person's options. Interrogation manuals of the era emphasized psychology over force. Officers were taught to speak calmly, to repeat questions patiently, and to project certainty even when evidence was thin. The goal was not violence, but exhaustion and inevitability. Suspects were encouraged to believe that cooperation was the only rational choice, that silence would only worsen their situation. In this environment, confession was framed not as surrender, but as relief. For people like Ernesto Miranda, this system was overwhelming. He was not facing a single officer, but an institution that spoke confidently and continuously. He did not understand that he could stop the conversation. He did not know that refusing to answer was legally protected. To him, silence felt dangerous, and speaking felt necessary. This confusion was not unique. It was common, and it was largely invisible to courts. The Supreme Court would later recognize that this dynamic mattered. It acknowledged that coercion does not always announce itself through raised voices or physical force. Sometimes it appears as calm persistence, as authority expressed through routine. When the state speaks with certainty and the individual does not know their rights, the imbalance becomes structural rather than personal. What made Miranda versus Arizona so powerful was not that it accused police of wrongdoing, but that it reframed responsibility. The court did not say officers were malicious, it said the system itself created conditions where constitutional rights could quietly disappear. By requiring warnings, the court placed a small but meaningful pause between authority and compliance. This pause changed the emotional architecture of interrogation rooms. The warning forced officers to acknowledge that the person in front of them was not merely a suspect, but a rights-bearing individual. It also forced suspects to recognize that they were participants in a legal process, not passive subjects of it. That recognition alone altered behavior on both sides of the table. In the decades that followed, scholars would debate whether Miranda reduced confessions or strengthened them. But beneath those debates lay a deeper truth. The warning transformed silence from weakness into legitimacy. It gave individuals permission to pause, to think, and to choose. In a system built on momentum and authority, that pause became revolutionary. Inside the Supreme Court, the arguments you never hear. When Miranda versus Arizona entered the chambers of the United States Supreme Court, it did not arrive as a dramatic story of heroes and villains. It arrived as paperwork, transcripts, and legal questions written in careful language. The justices did not see interrogation rooms, they saw words on pages. Yet behind those words were human moments, long hours of questioning, uncertainty, and silence that the court was now being asked to translate into constitutional meaning. The attorneys arguing the case stood before the justices and spoke not only about Ernesto Miranda, but about the nature of confession itself. They debated whether a statement could truly be voluntary when made in isolation, under authority, without knowledge of rights. The state of Arizona argued that voluntariness should be judged by outcomes, not procedure. If a suspect was not beaten, threatened, or physically harmed, the confession, they claimed, should stand. To them, requiring warnings felt like an unnecessary formalism that would interfere with effective policing. The justices listened carefully, but their questions revealed deeper concerns. They asked whether ignorance could be as powerful as force. They questioned whether pressure needed to be violent in order to be coercive. Several justices returned repeatedly to the same idea. The Constitution was written not only to prevent brutality, but to guard against subtle forms of domination that could hide behind normal routines. An interrogation room was not a neutral space. It was a controlled environment designed to extract information. Chief Justice Earl Warren played a central role in shaping the court's thinking. He believed that constitutional rights were meaningless unless they were practical. A right that exists only in legal theory, he argued, is no right at all. For Warren, the Fifth Amendment's protection against self-incrimination required more than silence on paper. It required a system that actively prevented the state from benefiting from a suspect's confusion. The court examined earlier cases and saw inconsistency. Some confessions were excluded, others admitted, often based on subjective judgments about tone, duration, or demeanor. This inconsistency troubled the justices. They began to see Miranda as an opportunity not only to protect suspects, but to bring clarity to the law. A clear rule, they believed, would serve everyone better than vague standards applied after the fact. Behind closed doors, the justices debated intensely. Some feared that the ruling would tip the balance too far toward suspects. Others worried that failing to act would allow constitutional protections to erode quietly. The debate was not about sympathy for criminals. It was about the role of the court itself. Was it meant to adapt the Constitution to modern realities, or simply preserve older interpretations regardless of social change? Ultimately, the majority concluded that the Fifth Amendment must follow the individual into the interrogation room. Custody changes the nature of communication. When freedom of movement is restricted, when authority controls time and space, ordinary conversation becomes something else entirely. In that context, the state must accept responsibility for ensuring that constitutional rights are not merely theoretical. The requirement to warn suspects was designed to shame police or to elevate suspects above the law. It was designed to mark a boundary. Before questions begin, the government must pause and acknowledge the individual's autonomy. This pause, the court believed, transformed the interrogation from an act of dominance into a lawful exchange. When the justices finally voted, the decision was narrow but firm. They understood the controversy it would generate, yet they believed that history would judge the ruling not by immediate reaction, but by its fidelity to constitutional principle. The opinion they wrote was careful, measured, and deliberate. It spoke in calm language, but its implications were profound. Inside the Supreme Court, there was no applause when the decision was finalized. The justices returned to their routines. But outside those walls, the law had quietly shifted. The Constitution had gained a voice that would now be heard before questions were asked, rather than after damage was done. Earl Warren did not come to the Supreme Court as a distant academic or a career theorist. Before becoming Chief Justice, he had lived inside the machinery of government. As a prosecutor, a governor, and a public official, he understood power not as an abstract concept, but as something that operates in rooms, offices, and institutions. This experience shaped how he viewed the Constitution. To Warren, the law was not meant to sit quietly in books. It was meant to function in real human situations, especially when individuals stood alone against authority. Warren believed that constitutional rights must be understandable to ordinary people. He often argued that the most important moments for the Constitution were not ceremonial, but routine. Arrests, interrogations, and trials were where government power touched daily life. If rights were not protected in those moments, then they existed only for the educated and the privileged. Miranda versus Arizona fits squarely into this belief. Warren saw the case as an opportunity to translate the Fifth Amendment into a practical shield rather than a distant promise. Inside the court, Warren worked not by dominating debate, but by guiding it. He encouraged his fellow justices to think less about hypothetical criminals and more about actual human beings sitting in interrogation rooms. He asked them to imagine confusion, fear, and the natural impulse to comply with authority. This shift in perspective changed the tone of the discussion. The case became less about control and more about dignity. Warren's philosophy rejected the idea that fairness and law enforcement were opposing forces. He believed that legitimacy came from restraint, not excess. A justice system that respected individual rights, he argued, would ultimately be stronger, not weaker. By requiring police to inform suspects of their rights, the court was not handicapping investigations, it was affirming the moral authority of the law. The Miranda opinion reflected Warren's careful balance. It avoided inflammatory language and did not accuse police of widespread abuse. Instead, it focused on structure and responsibility. The problem, the court suggested, was not bad actors, but a system that relied too heavily on silence and assumption. The solution was not punishment, but clarity. This approach drew criticism, particularly from those who believed the court was overstepping its role. Warren accepted that criticism calmly. He believed that the Constitution demanded interpretation, not preservation in amber. For him, the court's duty was to ensure that old words remained meaningful in new circumstances. The Fifth Amendment, written in the 18th century, had to function in 20th century interrogation rooms. Miranda versus Arizona became one of the clearest expressions of Warren's judicial legacy. It demonstrated his belief that the Constitution should speak first, not last. By placing rights at the beginning of the interrogation process, the court reshaped how authority was exercised. Power was no longer silent, it had to explain itself. Earl Warren would later reflect that the most controversial decisions are often the most necessary. Miranda was not popular with everyone, but it was consistent with his vision of a justice system grounded in respect rather than fear. Through this case, Warren left behind a lasting reminder that the strength of the law is measured not by how forcefully it acts, but by how carefully it listens. Not every justice agreed with the court's decision in Miranda versus Arizona. In the quiet pages of dissenting opinions, a different vision of justice emerged, shaped by concern rather than indifference. These justices did not deny the importance of constitutional rights, but they feared that the court had moved too far, too quickly. To them, the ruling risked placing legal theory above public safety. The dissenters argued that the Constitution did not require police to recite formal warnings before questioning suspects. They believed the traditional test of voluntariness was sufficient, trusting judges to evaluate confessions after the fact. In their view, the majority's rule was rigid and artificial, replacing human judgment with scripted language. They worried that criminals would learn to manipulate the system, choosing silence not out of coercion, but strategy. Underlying these concerns was a broader anxiety about rising crime rates in the 1960s. Urban unrest, social change, and political uncertainty created an atmosphere of fear. The dissenting justices worried that the ruling reflected elite detachment from everyday realities. They believed that law enforcement officers, not judges, best understood the challenges of maintaining order. One justice warned that the ruling would turn police stations into legal battlegrounds where technical mistakes could outweigh truth. Another argued that the Constitution was being stretched beyond its original meaning, transformed into a living document without clear limits. These dissents were not written in anger, but in caution. They reflected a belief that stability mattered as much as liberty. Yet, even within disagreement, the dissents acknowledged something important. They recognized that interrogation involved pressure and that the power of the state could overwhelm individuals. Their disagreement lay not in diagnosis, but in remedy. They preferred gradual change and judicial discretion over bright-line rules. The majority preferred clarity. Over time, history would soften the fears expressed in dissent. Crime did not spiral out of control because of Miranda. Confessions did not disappear. Instead, the dissents became part of an ongoing conversation about balance. They served as reminders that constitutional interpretation always involves trade-offs, and that reasonable minds can differ over how much protection is enough. The presence of dissent in Miranda versus Arizona strengthened the decision rather than weakened it. It revealed that the ruling was not inevitable, but chosen. It showed that the court understood the risks and acted anyway. In a democracy governed by law, such transparency is essential.